There is a pecking order of which you need to know. Certain pieces of legislation are going to beat up other pieces of legislation. They're the ones that are going to reign supreme. So you need to know what is the ultimate authority, and that's the Local Government Act. Next will come your letters patent. Local Government Act just applies to all improvement districts. Your letters patent say this is what's special about your improvement district. And if there anything in there, such as there may be regulations about how you conduct elections or what you can and cannot do, your letters patent is going to have that information. Don't worry, your staff is on it. They know, they've read it. They know what's needed, so don't worry, that's looked after. The next is your procedure bylaw, which is how are you going to run your meetings? But what you're going to find is your procedure bylaw cannot be in conflict with your letters patent, and it can't be in conflict with the Local Government Act. That if there's a conflict between the two, guess who wins? Local Government Act or your bylaw? Sorry folks, it ain't your bylaw. So whatever the Local Government Act says, you need everything aligning to make sure there isn't any problem. And then there are things that's just plain your customs. This is how we do things. It's not written anywhere, but it may be just things that you do at the start of your meeting, procedures, how you do line up for people wanting to speak, things like that. That's really at the bottom of the hill. So what you're going to look at is if your custom contradicts your procedure bylaw. What falls by the wayside? Your custom. Okay. There are other pieces of legislation that may apply, regulations with regards for the Water Act. Let's see, maybe freedom of information and protection of privacy, where people actually want to have a look at your records. So there are other pieces of legislation that you have to worry about. In case you haven't had this drilled into you, I will be drilling it into you a lot. You have to make decisions in legally convened meetings. What that means is that the trustees have been given notice of when the meeting's taking place, that it's called to order, that it's open to the public, unless you can find a reason to close it or go what they call in camera. With that, very limited reasons for that. You have a quorum present. You've got to have that quorum, the minimum number there, in order to have your meeting properly constituted. So you want to make sure you've got all these things in place. If that's the case, your decisions are fine, away you go. You must comply if there are any legislative restraints. So if there are certain things that are in place, you need to worry about those. Now, this is the parliamentary principles. The whole idea is that you collectively are going to decide what works for your group. You're going to determine what's reasonable, subject to any legislative restraints. The principles that are in place, not all of them are absolute. Some of them you've got a balancing act, but the general idea is that in order to balance the rights of the majority and the minority, that you're going to put some rules in place and you're going to decide for yourself what's reasonable. Your definition of what is reasonable is what is put in your procedure bylaw. That's your organization's official statement of this is what we think what is reasonable for meeting rights. So that's what you're going to look at. And if something's not working for you procedurally, you can change it. Basically, there's 8 of them. 8 basic principles, and if you ever boil down Robert's Rules of Order, you can boil them down to these 8 basic principles. The rules are all fitting in there. So the assembly is paramount. The majority must be allowed to rule. Minority has rights that must be respected. Everybody's equal. Courtesy and respect, please. Keep it nice, people. All decisions made in a properly convened meeting, and we've already talked a little bit about that. Once you've decided on something in the meeting, that's it. Move on to the next item unless you're going to use some sort of mechanism to bring it back for formal reconsideration. But the idea is, let's get on with it, folks. And also, if there's a breach of the rules, a person does have the right to ask for point of order. But you have to do it at the time the breach of the rules, the procedural rules happen. You can't wait till the end of the meeting going, yeah, by the way, we broke the rule, bad us. It's a little too late there. The assembly is paramount. That means your board, it's your board collectively is the group that is making the decision that's going to bind your improvement district to whatever course of action it is. What this means is, have you ever wondered why you have a seconder for motions? The idea is we don't want the whole group spending their precious meeting time dealing with something only one person wants to talk about. A seconder is a way of saying somebody else in the group says, I think this is important for us to talk about. It may not be that the person agrees with the motion who seconds it. That person may be thinking that is the craziest idea we've ever had. I don't think we should do it. But it's important enough. I want you to know it's the craziest idea we ever had and we should vote against it. Majority must be allowed to rule. For the most part, I mean, we kind of take it for granted, this idea of a majority rule, but that's not always the way decisions are made. We'll talk more about that in another section. But the idea here is that here's the issue and we let the majority make the decision. But the flip side of that, in order to allow the majority to rule, it means the minority, which means the people who may not hold the same opinion as the rest of the group, has a fair opportunity to put other points of view forward and for it to be seen. If the minority is not given the opportunity to speak and voice their opinion, the majority basically becomes a dictatorship. And that's not what you want to have happen. You want that fulsome debate. It's okay to have a difference there. So to make sure that the minority, or the people who may not be holding the current point of view, has that proper opportunity to speak, is that there are rules in place. And if you want to change up some of the procedural rules, you're going to have more than just a simple majority. So some of the rules in place that protect the minority is the ability to say, hey, we've had enough debate, let's get to the vote. If you're very precise in Robert's Rules of Order, it's called previous question. I call it shut up and vote. Sometimes you hear the vernacular used, I call the question. Has everyone ever heard that one? Call the question. Well, what you're asking the group to do is say, can there enough on the debate? Let's get to the vote. Well, that's a pretty serious thing to say, we're shutting down debate. So the idea with that is that 4 out of the 5, if you've got your group of 5, 4 out of the 5 say, you know what? It's okay. We're agreeing to shut down debate right now. But you're impacting the minority's rights. So the thing is, if it's only 3 out of 5 say, yeah, let's shut down debate, you've protected the rights of the 2 because the 2 have said, you know what? No, we need more debate and you're not going to shut down my right. You didn't meet that super threshold. So you've protected minority rights because they're allowing the debate to continue, because the right to debate, and I mean that from a discussion point of view, not just an argumentative point of view, is so critical that you really have to be careful when you're dealing with that type of right. So if you want to say, let's just get to the vote, you need at least 2/3 of the group saying, you know what, we're cool with it. The idea is that everybody's equal in terms of you express your opinion by a vote. And because you are all equal, you have certain equal rights, privileges, and obligations. One of them is the right to participate fully. Well, what does that mean? It means that you have the opportunity, if you are entitled to vote, you have the opportunity to make motions, to second the motions, to speak in debate, to make amendments, to postpone it, to do all sorts of things. You have those same rights as everybody else. And I'm sorry, my friends who are chairs, you're just like everybody else in this regard. No super votes for you. I'm sorry. The right to factual information before making a decision. If you think about it, the currency of a meeting is information. And the more information you have, the better decisions it's likely you're going to be able to make. So what you're looking at here is the fact is that if you don't think you have the information you need to make the decision, you can put forward a motion saying, hey, can we get more information? And postpone making this decision. That's okay, not a problem. The right to full debate before voting. And that means a full discussion. It doesn't mean that you absolutely have to talk about everything. It may be a situation where one trustee says, I move it. The other trustee says, I second it. Any discussion, says the chair, and all you hear is crickets. That's a cue to the chair saying, okay, the group is comfortable enough to proceed to the vote. So the chair will look around and say, okay, are you ready for the question? Okay, the question is on this motion to do X. All those in favor. Just because you didn't have a full debate doesn't mean you've skipped a step. What it means is that the group is ready to make the decision without needing full information. But it's at that time when the chair says, okay, are you ready for the question? And hands start popping up and asking for more information. That's okay too. And for debate, it's okay. You just have to provide the opportunity for that debate and discussion and the right to efficient meeting. Nobody says you have to torture yourself. It's like we talked about with previous question, or call the question, or what, shut up and vote, whatever you want to call it. That's an idea of an efficient meeting, is that recognizing, you know what, we're not adding anything new, it's probably not changing it around, can we get this meeting moving along? Okay, if there's any restrictions, they have to apply to all members, that you just can't pick on people with, I don't know, brown eyes or green eyes or multicolored eyes, you know, it's going to apply to everybody. If you're a member, these restrictions apply to all. Obligations, you just don't have rights, you have obligations as well. The idea with this is that you're going to follow the rules of the organization, so you're agreeing to abide by the procedure bylaw and the legislation, but most importantly, you're agreeing to abide by the decisions that are made in the meeting. So even though the motion was passed, you didn't vote in favor of it, and man, that really, you know, frosts your cupcakes, but you still have to support the decision that was made. If you really cannot support the decision that was made, your option is basically to quit, to resign. If you really, in your heart of hearts, going, I just can't do this. Courtesy and respect. The idea is play nice in the sandbox. So with this, you're entitled to your opinion. And you're entitled to be respectfully treated for the opinion you hold. People, you don't pick on people, you look at the idea. You know, you may say, I don't think that's the best course of action, not you're stupid. That's not nice, you do not say that to other people, okay? So the idea with this is that we're not going to be interrupted, that you're going to follow the rules of debate. And we'll talk a little bit about those rules as well. Generally, interruptions of speakers is prohibited, unless there's something really, really urgent. Let's see what else. Properly convened meeting, I told you about that. Oh, call to an order at the notified time or later. Sorry, you can't sneak a meeting earlier. If you said you were going to start at 7, but the one you don't agree with, that trustee's not there, and you say, well, we're all here at 6, let's get going. Bad form, bad form. Because also, your meetings are open to the public. And what would they say is you're finishing up the meeting, you know, 5 minutes to 7, they're just walking in and like, yeah, see ya, just finished the meeting. I don't think they'd be too thrilled, would you? I know I wouldn't be happy about that. Anyways, also that you've got a presiding officer, that would be your chair, and a secretary, and I mean that's who's ever responsible for doing the minutes for your organization. Because the idea is you need somebody to worry about the procedural stuff and somebody to capture what was done. So you've got an official record for it. Some people ask, well, is it just enough that we tape record a meeting? No, you're going to need some minutes that are produced from that meeting. And we'll talk about different style of minutes if you want. But the idea with all of this is that you've got an official record and that the group at its next meeting says, this is our official record. That's what the minutes are doing, is saying, this is everybody saying, yep, that's what happened at the meeting. And that you've got a legal documented trail. All right, here are some of the constraints, which you probably know, you just may not have always thought about how it is. You only have authority to make decisions for what falls within your jurisdiction, your boundaries, your area. Your letters patent will tell you, hey, it goes to this property and no further. So you have the authority for making decisions that'll happen within that boundary. Outside of the boundary, well, somebody else gets to make those decisions. Now, I understand there is a bit of an exception with regards for fire protection if it's going over there, but usually you'll have mutual aid agreements and that to allow your fire departments to go next door. Can't override federal or provincial regulations. So not only does the province tell you, hey, these are how these rules work and certain regulations, same thing with the federal government. So if the federal government says you have to do X with regards for your water supply, I'm sorry, my friends, you have to do X. In a meeting, chair has extra responsibilities. In other words, making sure that the meeting proceeds accordingly, follows up with paperwork and things like that, but doesn't necessarily have any more rights or extra powers. Just because you're the chair doesn't mean you can say, well, do this, do that. It all depends on the decisions that are made by the board. You must have adequate funding for the services. So you can't sit there and run a deficit, my friends. Got to make sure you have the money to do what needs to be done. Apparently, your funding is only done by user fees or taxation. Every toll, it must be established by bylaw, because the idea with a bylaw is that it's been officially sanctioned by you and you've gone through your process. All right, you must hold an annual general meeting. Sorry, you can't skip out of it. You've got governmental aspects, and then you're almost like a society or a corporation where you have to go back to your shareholders or the stakeholders and say, hey, you cool with this? This is what's going on. I mean, that's how you have your elections, is through your annual general meetings. So you need to have one, especially if there's a changeover or if somebody's term of office is over. You have to record your minutes. That's a public document. And so you know when I talked about freedom of information legislation, when I talked about that, that means if somebody would like to have a look at your minutes, under freedom of information and protection of privacy, they can have a look at your minutes. Also, the Local Government Act and your letters patent is going to say this is how you run an election. So you need to look at your legislation to get it right. With bylaws, now you've got a process where you're going to introduce, here's the rules we want people to follow. You do it through a bylaw. Because of how you are set up, previously, as I understand, you used to have to send all your bylaws to the Inspector of Municipalities to say, it's okay, you can do that before those bylaws could take effect. There's now been a switch, and that some of them, you still have to register with the Inspector of Municipalities. Others, because of their very nature, you don't have to send them there. If you do need to have your bylaw approved by the ministry, I would highly suggest you talk to the ministry before you even start drafting the bylaw. If it's got to be done by bylaw, then you have to do it by bylaw. Just passing a simple motion is insufficient if it says you got to do it by bylaw. It's got to be in a legally convened meeting, in case I didn't harp on that enough. Legally convened meeting. Apparently, your bylaws don't have to be approved by the landowners, but you probably will have to do some consultation in advance to get an idea, especially if you're putting lots of money that they're expecting them to pay. Yeah, you may want to get a heads up. And remember, the inspector can refuse to register if it's in the opinion that it's not in the interest of the improvement district or the province. They can't be retroactive. So the idea is you can't pass a bylaw July 1st and say, guess what? It goes, it's effective as of January 1st this year. It can be January 1st of next year, but the idea, especially when you're charging money, and this happens with local governments as well, it's got to be forward-looking. And that you can't use tickets or levy fines to enforce your bylaws. You can put charges, penalty charges in that, but you're not going out and writing tickets. Fiduciary responsibilities. The idea with this is that you are in a significant position of trust, and other people can suffer. The whole idea with the fiduciary is that recognizing that other people are vulnerable because of the position that you're in, and if you choose to abuse that position, and I'm not saying you are, but if you choose to, they really could suffer some damage. You have to be cognizant and recognize that your responsibilities are to those people there and to their best interests when you're making those decisions. You represent what the community is thinking. Stewardship, you're going to be responsible with the assets. They're trusting you with those assets, that you're going to make the best decisions to preserve them, to make sure it continues to function. You're going to put policies in place, and you're actually going to make decisions passing bylaws. So you've got a number of different responsibilities, but it all ties into this whole idea of fiduciary responsibility. Okay, the idea with the duty to act honestly, that you're going to be candid with the information that you're discussing at the table. You're not hiding anything. You've got it right out there. That you're not acting for an improper purpose. Due diligence is the idea is that if you've got that little niggly feeling in your stomach going, maybe we should look in that, but I don't feel like doing it. That is not being diligent. The idea is looking after to make sure that you're attending to your legal duties, making sure that you're following along with what it is, that you're acting with best judgment, that you're just not making decisions going, yeah, whatever, that you've thought about it, that you're acting in the best judgment. Maintaining proper minutes. Duty to exercise power is you're ultimately responsible for the organization. So inaction or inattention, just kind of ignoring like, yeah, I know I'm supposed to do it, but I can't be bothered, is not acceptable for that standard. The idea is that you have that and you're expected to take action when action is needed. That you're going to spend whatever money for the purpose that it was collected for. And duty of obedience, I know that sounds crazy, but the idea is that you're going to comply with the laws and policies that are in place, and that you make sure your corporate decisions are actually implemented. Duty of loyalty is you've got to act in the best interests of the organization. And what you're dealing with here is this whole issue of conflict of interest, with the idea is that, especially as a fiduciary, is that you are not going to let your personal interest conflict with your responsibilities to make decisions in the best interests of the improvement district. So if there is a conflict of interest, that you're going to step aside and say, you know what? There's a problem here. I'm in a conflict of interest. I don't want to create any problems for you. And basically what I call zip it. You're not going to be involved with the decision making. You're not going to try to influence the other trustees saying, hey, come on, it's for my benefit. You like me, don't you? But the idea is that you remove yourself from whatever decision is putting you in a conflict of interest. And the thing is, when you have a conflict of interest, you have the potential for people to attack the decision. Because what they're saying is, if you're in a conflict of interest, you're biased. And it makes that decision subject to attack.